Hello and welcome to Point One. 6 minutes of ethics a day could keep the legal malpractice claims away. Unfortunately, no guarantees. Today we'll be discussing New York State Bar Association Ethics Opinion 1213, which involves rules 5.4a, 7.1a, and 7.2a. The question presented to the committee was, does the portion of the legal fee paid by a client but retained by an online lawyer matching service constitute an impermissible referral fee? So it's a lead generating service the lawyer is interested in participating in, and of course there's a fee involved, and the question is whether that's an impermissible referral fee. Jumping down to the conclusion, a lawyer may not participate in an online lawyer-client matching service that vouches for the lawyer's credentials, competence, and effectiveness, and recommends the lawyer as the, quote, best lawyer for the needs of the potential client. A lawyer participating in such a matching service would violate Rule 7.2a. So the facts here, the inquiring lawyer wants to participate in this online service that connects potential clients facing traffic violations with local attorneys willing to represent them. The lawyer matching service has a platform that requires the client to upload the ticket and provide some other information, and uses a proprietary algorithm to match the client with, quote, the best local traffic lawyer for their case, end quote, and quotes a legal fee that was predetermined by the lawyer that the algorithm selects. Once the fee is paid, the client's paired with the attorney who has to accept the case in a day, or they move on to the next lawyer. The legal fee minus the service charge for the matching service is then transferred by the service to the lawyer. So the client pays the entire fee to the service then pays the lawyer and takes their piece. The inquiring attorney says the algorithm is driven by a variety of factors, including the lawyer's location, fee schedule, success rate, local competition, and customer service feedback. The online matching service collects feedback from its customers, clients, and in its discretion can offer a full or partial refund in the event of an unfavorable outcome. The service represents clearly that it is not a law firm, does not provide legal advice, and all attorneys it connects clients with are not employees or its agents, and the online service is not owned by New York admitted attorneys. So the opinion cites to a series of rules, Rule 7.2, and notes specifically the language of 7.2a. A lawyer shall not compensate or give anything of value to a person or organization to recommend or obtain employment by a client, or as a reward for having made a recommendation resulting in employment by a client. The opinion goes into the comment 1 to Rule 7.2 states that this paragraph does not prohibit a lawyer from paying for advertising, and that a lawyer may pay others for generating client leads, such as internet-based client leads, as long as the lead generator does not recommend the lawyers. So as we'll see here, the problem is how this online lead service actually is recommending the attorneys to the potential clients. Comment 1 continues with, of course, having to comply with Rule 7.1, avoiding false, deceptive, misleading attorney advertising, and a lawyer may not pay a lead generator that states, implies, or creates a reasonable impression that it is recommending the lawyer or has analyzed a person's legal problems when determining which lawyer should receive the referral. So again, here the problem is going to be that the committee finds this particular service is crossing the line and sort of recommending a specific lawyer through this algorithm in a way that is impermissible. Here, the matching service is a lead generator, the opinion decides, and as such, the committee has to determine whether the service recommends the lawyers rather than just referring them. The rules generally do not allow lawyers to pay for referrals of clients, and the opinion goes into Ethics Opinion, New York State Bar Ethics Opinion 979, discussing those issues, and Ethics Opinion 1132, and sort of uses the two to show in 979 where a referral service is available. It's a group of lawyer mediators who pay essentially for joint advertising rather than paying for referrals. And then in Opinion 1131, it's juxtaposed in that marketing service instead is one that's unethically paying for a referral fee. So the opinion goes through those two sort of opposite ends of the spectrum, and then notes in Opinion 1131 that lawyers participating in a fixed monthly fee service, which submitted their names, contact info, geographic info, and practice areas, that could be allowed. Based on the neutral factors for the service used in Opinion 1131, that did not violate the prohibitions against paying for a referral. The opinion continues on, again, discussing Opinion 1132, and specifically the lawyer matching service by the famous, at least for attorneys, AVVO Legal Services, and where in Opinion 1132, the committee noted that AVO had crossed the line from a permissible marketing service to an impermissible payment for a recommendation in violation of Rule 7.2a. In that opinion, 1132, the committee noted that AVO gave each participating lawyer a rating that was advertised as potentially helpful for a client to, quote, quickly assess a lawyer's background. And there was a scale of 1 to 10, calibrated in 1/10 increments, suggesting a degree of mathematical precision that the committee had problems with. And the advertising for this AVO program in Opinion 1132 also claimed to, quote, enable a potential client to find the, quote, right lawyer for their needs. So the right lawyer issue comes up here. Ultimately, the problem that the committee has is that this online, in our opinion, is that this online matching service is claiming to select the best or the right lawyer for the potential client, using its algorithm rather than simply referring clients to lawyers, which would be accessible. The rule stops short of going into two other questions that arise because it's determined that this is not permissible. The two questions about fee sharing and advertising. It goes short of addressing those because it doesn't need to. But I think the big takeaway here is to be careful. AVO is a major outfit. It auto-generates bios for attorneys. It's national, but you can't assume they know or care what they're doing. The responsibility remains on the attorney. So LinkedIn, even your firm's website, at the end of the day, you're responsible and need to make sure that you're presenting yourself in an ethical way and attracting clients in an ethical way. That's been our point one for the day. Thank you for joining me.